Companies Act, a special presentation by The Firm.
The Companies Act 2013 is to governance what voters hope Mr. Modi will be to politics. Transformational. Whether it's the Harshad Mehta scam of the 90s or the Satyam fraud of the last decade, they've all left a deep imprint on the design of this new law, prompting India to legislate provisions such as director rotation, auditor rotation, minority rights protection, much ahead of the rest of the world. But can good governance be a top-down effort? Well, that's what we're about to find out today. Hello and welcome to Companies Act, as we focus on Chapter 11, Appointment and Qualifications of Directors, and Chapter 12, Meetings of the Board and its Powers. To navigate us through these new waters, I have with me Y.M. Deosthalee, the Chairman and Managing Director of L&T Finance Holdings, well-known Independent Director Naushir Mirza, Cyril Shroff, Managing Partner Amarchand Mangaldas, and Bharat Vasani, Chief General Counsel, Tata Group. Gentlemen, to all four of you, a warm welcome to this series. The Companies Act 2013 mandates a minimum 3 directors for a public company, 2 for a private company and 1 for an OPC, and maximum 15 directors, beyond which a company needs approval via a special resolution. Government approval is no longer required. A woman director on board is a must for all listed companies, and public unlisted companies with a paid up share capital of 100 crore rupees or more, or a turnover of 300 crores or more. Compliance time for all of this? 1 year starting April 1st, 2014. That's also the time available for all listed companies to ensure that at least 1/3 of their boards are independent, and for all public companies with a paid up share capital of 10 crore rupees or more, or a turnover of 100 crores or more, or outstanding debt of 50 crores or more, to appoint at least 2 independent directors on board. The 2013 Act for the first time recognizes and defines the concept of an independent director. A managing director, whole-time director or nominee director cannot be an independent director. An independent director should be a person of integrity, relevant expertise and experience. The Companies Act 2013 lays down several provisions for an independent director to meet in order to be able to prove his independence. Mr. Vasani, do you notice any big material changes in the definition?
Yes, and I tell you, I can give the background since I was also part of the Dr. Irani committee.
Sure.
The big debate going on was that should we allow the financial institution nominees, which are FI nominees, which are should be regarded as independent. Clause 49 of the SEBI listing agreement allowed FI nominees to be regarded as independent director. Dr. Irani at one stage, I will quit the committee as a chairman of the independent committee if they be regarded as independent. They are representing the views of only one stakeholder, that is for institutions appointing them. So after much debate, it was decided that the FI nominees which are regarded currently as independent directors will not be. So that's a very major change.
Sure.
And many of the Indian boards have a FI nominees as independent directors, so they will have to induct additional people as independent directors.
So to be fair, all nominee directors have been disincluded from the definition of independent director.
Marika, you know, the result of this definition is that you have an absurd situation where if an independent director in the parent is nominated to the board of a major subsidiary, he is not regarded as independent because he has been nominated by the parent.
Oh, so he becomes a nominee director.
He becomes a nominee. So you have an absurd situation where the man is considered independent at the parent, but not in its 100% owned subsidiary.
There is one more point here.
Yes, sir.
It's not necessary that they are nominated by the parent. It so happens that the independent director is on the board of the parent company as well as the subsidiary company. There is no nomination here. For example, in one of our boards, I can take a name, so I don't want to take name.
Okay, X.
There is X person, we appointed him on the subsidiary company first, because we thought that his contribution will be very valuable for that particular business which that subsidiary runs. Later on, he was appointed on the parent board. Now, it's a situation today that he is on the boards of both the companies, but because of this particular provision, he ceases to be independent on the subsidiary company where he was appointed first. And he is an independent director on both the companies. Will he be construed as a nominee of the parent company under such circumstances?
I think we should look a little deeper. It's not just the mode of appointment, but I think it's really conflict of interest principle that is the real reason.
Between the parent and the subsidiary?
Yeah, so if the implication is that when you're really representing the interests of another body on the board of another, you are not then truly acting independent of all conflict, but you will always have a bias in favor of your so-called parent entity.
So you're saying,
and
in fact, the Companies Act has done the right thing by saying that if you are on the board of the subsidiary at the behest of the parent, then you are a nominee director and you cannot be independent.
That is the effect of what has happened. But I think I would sort of step back a little bit and question as to whether there was any necessity of defining independent directors separately at all or not. Because all directors are separate, all directors are fiduciaries. They are all expected to act free of conflict and in the best interest of the company. To give this additional label and responsibility
but you had to define independence, right? You had to make sure that people knew clearly how you would become an independent director or where you would be disqualified as an independent director. So that was important.
From a Companies Act perspective, I would question whether this was necessary at all or not, and that could have been left to things like clause 49 or the listing agreement. But from a public market perspective,
is essentially a company law concept, not so much of a securities law concept. A second thing, I want to point out that clause 49 of SEBI requires, listing agreement requires that for material subsidiaries you need to have an independent director on the board of a holding company to be on the board of subsidiary.
What is the net effect of what this new provision in the company law does?
It would lead to, if you need an independent director in a subsidiary company, you would not only have one person who is consuming one position, you will have to have two independent more to make up for the...
There is another implication of this. Consider a situation where you have a joint venture, where the powers between the two partners are quite clearly defined. Now you suddenly introduce two new individuals who are not aligned to either side. And until now there's been a balance. Now suddenly you have an issue on the agenda where depending on which side these two people move, the balance of power could shift.
Really to,
so they become extremely crucial in joint ventures.
So what you're in effect saying is that these, in fact, the whole concept of independent directors should never have been extended to anything which was unlisted.
I have a slightly different view on this. In fact, this was also debated in the Irani committee. One of the point was that the unlisted companies also have a lot of public funds and public resources, and in effect, effectively the promoter directors or the directors of two partners in case of joint ventures, they represent the true interest. And I have been on the boards of several joint venture companies. I find that the nominees, partner A nominated 3 directors, partner B nominating 3 directors. They look at only their parental interests. I have never seen they looking independently at company's interests. So if there are 2 directors, and they are not saying you have 1/3 of the board, but 2 directors. So I am in support of the argument where there is substantial public money involved, even if it's unlisted company.
Remember, now we have to issue consolidated financial statements. The board of the parent is answerable for a consolidated performance. They are no longer responsible for that performance because big chunks of that performance could well have been determined by a group of individuals who are not listening to them.
Okay, but how do you resolve this situation? My point is, if you have a situation that Mr. Deosthalee is currently facing, what do you do?
I don't know. It's a little, he's saying he was never nominated.
But no, let's accept he was appointed on the subsidiary company first.
Okay.
Part of the problem is that
this is the new normal.
Mentally free. So this is the new normal.
Companies Act, a special presentation by The Firm.
The Companies Act 2013 has great expectations from an independent director. Some part of this is evident in section 166 that lays down the duties of all directors and begins by saying a director of a company shall act in good faith in order to promote the objects of the company for the benefit of its members as a whole and in the best interests of the company, its employees, the shareholders, the community, and for the protection of the environment. And then there's Schedule 4, 2 pages of guidelines of professional conduct, role and functions, and duties of independent directors. They range from simple to, not so simple. How do you see roles and responsibilities change?
So far as I am concerned, I don't see any need for me to change the way I have always behaved.
No, fair. I'm saying broader community.
I think there are 2 major changes on independent. One is, you may remember that Gandhiji used to have a little figurine on his bedside, the 3 monkeys. Speak no evil, hear no evil, and see no evil. Now many independent directors practiced a life inspired by those 3 monkeys. They would refuse to hear anything that was negative about management or the promoter. They would certainly not speak it. And about seeing it is not relevant in this case. Now the Act compels them to open their eyes, open their ears, open their mouths, and to poke their noses into everything, and the whole diligence issue which we should discuss. into everything that till now they hesitated to. So I think that's the first major change, and it will see a manifestation in the way these people behave in board meetings, where you won't have one individual like me, but you'll have half a dozen individuals who will all try to put their voice in, have it minuted that he said this or he said that or he objected to this. That's one. The other significant change I see, Manika, and many people are still unsure about it, is there's a requirement in the 4th schedule, and it's in a number of other places, which says the company shall balance the conflicting interests of all stakeholders.
Yeah.
Now also, this was a requirement, but now it's written into the law. And you have a situation where essentially environmental groups could well use this to attack a board and say, demonstrate to us you balance these interests. Let me give you an example. I am on the board of a company that does medical research. I am not on a board of research, but suppose I was on the board of a company that does medical research, which includes testing on animals, which is a very, very cruel thing. I could receive a letter from PETA saying, demonstrate that how your shareholders are making money, it's good for humanity, all of that we agree. But demonstrate how you balanced all of that versus the cruelty to the animals who are the subject of your
But wouldn't it
research.
be a question you would ask in a board meeting anyways, with regards to any
No.
company that could have a
course you would
deleterious
ask.
impact on the environment, on what that company is doing to minimize that
Manika,
impact?
you
Best
would
practice.
ask, how would you demonstrate a balancing? You know, when you say a balance, means you have to have a common measure by saying here is a kilogram and here is a kilogram, or here is a crore of rupees, here is a crore of. By what measure do I strike such a balance?
No, I get what you're saying, sir, and I think in that lies the big question that Schedule 4 throws up. Do you treat it only as a code and a set of guidelines, and if that was the only thing you had to do with it, then that would be fairly easy to deal with because it's a best practice manual, so to speak? Or do you treat it as something that comes with a potential liability if you don't follow to the word
also
everything that's in the
section.
code?
It's a part, you read 149(8), which says the company and independent directors shall abide by the provisions
abide,
of.
yeah, we
So
don't
it's a
have a-
shall, the word is not may.
Yeah.
And you know, it's very clear that it's a kind of a,
not a take it or leave it.
take it
If
or
that
leave
is the case, then let me read out some other things in Schedule 4 that are equally alarming, which is, for instance, if you look under Section 3, which is duties, not to unfairly obstruct the functioning of an otherwise proper board or committee of the board. Now, if you have, as you have been, Mr. Mirza, a vocal independent
I don't
director,
unfairly obstruct
any, but I could interpret it as unfairly obstructing if you were asking
No, that's if the
rude
rest of
questions
the
of
board,
the management.
board said that.
So so just to add to your point that some of the wording, could be interpreted in several
No,
different
that will
ways.
get refined over a period of time, but I don't think that's a very serious issue.
I think the bigger issue is if you haven't, if it's not minuted, it's not counted that you said it. And so, you know, if you have an objection, you must make sure it's minuted. And then when we come to the diligence thing, you know, it says directors should be diligent. So they'll all want to demonstrate diligence by making sure the minutes capture lots of points
But isn't
they
that
made.
lovely?
Just to comply with this, there will be comments made in the board. The fear is that. The second important point is that looking at it from an objective perspective, I think it's very essential for independent directors to get exposed to many of these aspects, because all these years I'm not sure whether all independent directors were really looking at risk management or strategy or contributing in the affairs of the company in the right sense. So it's very essential for them to really get oriented in a much objective manner. That is one. And secondly, there is also an evaluation process which has been defined. So if they are going to be evaluated based on these factors, what is their contribution on strategy, what is their contribution on performance, etc., etc. Then in that case, I think all what he said is, I commented on this performance, I only pointed out this is what I said on the new business line which you want to get into. So whether it is really real value addition or not, I think this is a process. It will take some time. Overall, if it is done well, I think it will definitely improve the effectiveness of the boards.
I agree about that.
What I can say
ultimately it will
from
improve.
couple of board
I agree
meetings I
about
had after 1st of April, within 1 month this act has been able to have a very profound impact on the psyche of the independent directors. Suddenly I find that perception has been created, you know, that I am more accountable, I am more answerable, I am more liable, and I am more empowered.
That's a good thing.
So that's a good thing, but if they concentrate on issues such as strategies, performance, etc., that's a very good thing.
Sure.
But if they focus on vigil mechanism and they focus on...
but that's also part of their job.
I understand. But in the process, if they start introducing processes in the organization where a lot of data is collected and presented to them on what's happening in the company, who is doing what, so this watchdog concept has to be properly understood.
Okay,
Mr.
Shroff, this conversation that we're having on roles and responsibilities is a little incomplete if I don't bring up the issue of liability. And so just for the purposes of making clear what the independent director liability is, I'll read out that section of the Act which goes on to say that a non-executive director not being promoter or KMP shall be held liable only in the respect of such acts of omission or commission by a company which had occurred with his knowledge. So that's a limiting of liability. Attributable through board processes, a further limiting of liability, and with his consent or connivance, yet another limit to the liability. But then it goes on and becomes free for all, as Mr. Mirza will say, because it says, or where he had not acted diligently.
I think firstly, this is just a partial savior to the sort of fear that many independent directors had about being harassed by proceedings or criminal proceedings that are filed against the board, and there's a long list.
Many of them are under other acts.
Exactly. So I was coming to that.
Other pollution control and all of that.
The limited protection that this offers is only in relation to offences under the Companies Act.
Right.
As far as all other breaches are concerned, nothing has changed, and the only way that could have been changed would have been to amend the Criminal Procedure Code and provide some procedural safeguards over there.
But that hasn't happened.
But that hasn't happened. But I can step back a little bit and see concept of liability in a slightly broader context apart from just penal proceedings in this. And there's a big sort of looming event on the horizon as well, which is class actions. And I think that will perhaps override a lot of the discussion that was just had, whether it is have you acted diligently, have you acted without conflict, have you balanced various interests or not. The place where it will finally get tested is in the class action, because and that will be a very US Delaware style of discussion, I think, that will take place, because there it is much more qualitative in terms of its analysis, in terms of whether the board acted properly or as a reasonable person would, and I think that's where you'll see all these things come in. So another section which should have been probably discussed is section 166. I think Naushir mentioned it implicitly, but that is where the whole concept of balancing the interest of the owners, the employees, the community and the environment. These are all very big concepts
which
are actually impossible to balance, frankly. So it's a question of whether it will, my guess is eventually properly interpreted, it will come down to have you applied your mind adequately to all these factors or not, rather than questioning a decision, have you avoided extremes or not.
What happens if you are found not to be diligent?
There's some guidance available in one of the Supreme Court judgment. I think Justice Tendulkar had delivered it years back, that if you are willfully shutting eyes in terms of what is presented to the board and you still choose not to raise the issue, then you are...
Let me give you an example. I am on the board of a property developer. Everybody knows property development involves black money. Have I been diligent and asked in the board, how are you accounting for the black money in our business? So this is diligence.
I think we're making too much out of this, because even without this word language, I don't think there was any excuse for not acting diligently. Even the common law as well as the old act was good enough.
Always there.
So this only restates the obvious.
One has to look at diligence in the way in which is understood by common man, the common people. I mean, whether you are doing investigation.
Everybody on this panel, with the exception of the independent director, seems comfortable with this. So I'm going to ask the independent director to tell me how life has changed for you after this new description of your roles and responsibilities, this new description of your liability.
Essentially that you need to prepare yourself much more. You need to read beyond what's the material supplied to you by doing whatever research you need to before you appear in the board meeting or a committee meeting, and then in those meetings to ask and be satisfied with all the explanations you receive. Be satisfied. It's not sufficient to just receive an explanation that's not believable, like the example that you're told there is no black money in our property development business. There are businesses like that where there isn't. So you've got to be reasonably satisfied that yes, it is that kind of business and it's not one of the others where maybe there is.
And you've got to make sure that all your views, opinions and these discussions that lead to that satisfaction are all minuted in the board meeting, so that tomorrow if somebody asks you a question, either a judge or in a class action, that you are able to show the minutes as proof of you behaving diligently.
Correct.
Would that be a fair assessment of how your life is changed?
You've got to be balanced and behave with some maturity, and I don't think I would expect that all the 47 points I make in the course of a board meeting should each figure in the minutes. Maybe one should, or maybe two should.
What I'm seeing is there are certain important corporate transactions, like an M&A transaction, for instance. There, the level of discussion and the consideration of process is much more qualitative. But on ordinary stuff, I think it's coming down to asking some basic questions. So I don't think on those kind of things behavior has changed as much.
So you don't think the liabilities of independent directors have increased?
I think there is a general feeling that our liabilities have gone up because firstly they've got codified, there's so much of a spotlight on independent directors.
But in reality,
but if you look at it from a purely legal liability perspective, I don't think much has changed because these liabilities always existed.
Companies Act. A special presentation by The Firm. A special presentation by The Firm.
In a unique first measure for India and probably the world, the Companies Act 2013 restricts the tenure of an independent director to a term of up to 5 consecutive years, after which a special resolution approval is needed for reappointment for another term of up to 5 years. Thereafter, a 3-year cooling off period is required before any reappointment. This provision is prospective, that is, it does not count any previous term served.
After considering the entire provisions of not only 149, which deals with the independent directors, but also 465, which is not notified, which is the repeal and savings clause, there is no choice, I think, corporates have but to appoint all their independent directors
Again,
at this AGM, the first AGM season of 2014.
even if they have not finished 5 years.
Even if they have not finished the previous term, because the term is not saved. The second thing, the 149 doesn't it contemplates an entirely new Shastra for independent directors. Appointment, the manner of appointment, how they will be appointed, the explanatory statement, appointment letter to be issued. Their entire nature of appointment has changed. They no longer will be retiring by rotation.
No, there is no retirement.
Fixed
The
term for
entire
5.
concept, and that concept was not there in the 56 Act.
Yeah, get it.
So what is the 56 Act appointment, which would have been saved under 465 2D, has not been saved. So you have no choice but to appoint, and I have considered 2 senior counsels who are experts on company law concur with my view that it's a better and safer view to take that all of them have to be appointed at this AGM again. Now the complexity has been created by SEBI circular of 17th April 2014, which says on completion of its present term. So if you appoint them now for 5 years,
Then you've got 5 years plus another 5 years, so you've
because
technically got 10 years.
AGM season will get over by 30th September. SEBI says on 1st October this new provisions will apply. I believe SEBI has now realized that this may be misused, that they intended that the persons who have completed 5 years should not get 5 plus 5. So they may clarify that the present term which they meant in the circular was the term which was existing on the day of the SEBI circular, that is 17th April, and not what we got appointed at this AGM season. But I don't think the corporates have a choice but to get all their independent directors appointed in the manner prescribed in section 4 of schedule 4, in the manner they were laid down.
So I have a different view.
Please tell us
So
why.
it may be that you can start, just in order to avoid any doubt, if you like, you can start a fresh term of 5 years from now and ignore the past. That's one view which I think Bharat canvassed.
Isn't it safer?
Safer
Rather than taking some
The
other
views which I
Please, safer
I
is
think it's
what
very
Mr.
fair.
Vasani
I
says.
spent
I
last
think
10
no
days
appointment of
only
5 years.
I think it's
evaluating
very
this
fact specific, so I don't disagree that may be one way of doing it. That's one way of
much
doing it.
safer way of doing it.
But merely because I think the test would be that if somebody has not been reappointed and continues with his normal term, would you say that his appointment is defective? The other way of doing it is perhaps don't try to reappoint him, because why meddle with that term? Just just mention it and have it noted at the AGM that is coming up, that this is sort of a continuing for the
But
balance
still,
term.
just answer me, how do you
But
comply
why-
with 149 which has come into force on the 1st April if you don't do anything? The old directors who are appointed under clause 49, which does not match with 149, and continue, then they will not be regarded as independent directors
But
under
they-
149, and technically will be in violation of 149 that you have not gone through the process.
There should have been a provision which would say that all appointments will have to be freshly done
Then I
effectively.
think
which
MCA
is
may
not
come out
there.
with a circular.
So
but
when they come out with that circular, that would be, I think that would change the
one
process.
A director can hold up to 20 directorships, including a maximum 10 on public company boards. In aggregate, that's less than what the 1956 Act permitted. Also, a company can, via a special resolution, further restrict the number of directorships. The 2013 Act introduces new grounds for director disqualification, including permanent debarment. It punishes absentee directors by forcing them to vacate office, and it requires, for the first time, a director to resign in writing and send detailed reasons to the registrar.
Bigger issue, Manika, is I chair a few nomination committees. That you bring on an unknown person as an independent director, unknown in the sense that he's not previously been there. I'm now looking at a brand new person, and you bring him in for 5 years, and you don't know how that person's going to behave. You have the choice of, in the course of evaluation, say in the second year, third year, asking him to go. But now there is a requirement that if anyone resigns, he has to give his reasons for resigning.
Yes, of course.
Which independent director is now going to write that in the course of the evaluation process, I was found to be incompetent and asked to go? Now there's another issue. Even if he were to give a false reason, the reason has to be put up by the company on the website.
Right.
So the company then becomes a party to that deception because the company is aware why he's been asked to go.
Mr. Mirza,
And
you're
so-
too honest for this act, sir. You have to say, Baba, we disagreed, or personal reasons.
No, one sec.
That's the best thing.
Then
All directors use
then
that.
section 447 gets activated. That were you a party to a deception?
And the debate continues. Next week, we discuss board committees, intercorporate loans and investments, and related party transactions.
Companies Act. A special presentation by The Firm.